Welcome, everybody, to Spotlight on Success. Today, I have a special treat for you. What we do here on Spotlight on Success is we highlight iconic leaders of today, people that have interesting businesses, dynamic entrepreneurs and business owners that are making a complete change in the landscape of business. And these are companies and businesses and owners that you really want to connect with because they can also have a significant impact on your business. And today is no different. I have a wonderful guest today, Senami Craft. She's an award-winning commercial contracts attorney, and she is based in California. And she has a really interesting take on her business, what she does, that we're going to dive into. Now, if you have a business, but you don't have your own legal firm in hand, or maybe you do, but they're a little overwhelmed, but we're talking today about contracts. This is what will make or break your business. And we're going to give you some examples today on what works and what doesn't. How do you apply this in your business? And we're going to really break it down into about 3 or 4 simple steps so that you can walk away with something that you can use immediately. And if it is foreign to you, like, I don't know, this is too much, then you're going to want to reach out to our guest, Senami. And she is one of these people that when you think of an attorney, all the attorney jokes, this is not who you think of. She is an amazing, amazing human being. And I want to introduce you. Senami, welcome to Spotlight on Success. And let me go ahead and unmute you so that everybody can hear you. Let's try that, see if that's working.
Thank you so much for having me today.
I'm so glad. Now, Senami, I know you're very humble, so you don't tell people some of the amazing accomplishments you've had. You have one of the most unique models in law and legal firms, and if you're an attorney listening, you're going to want to wait to hear about this. And you've also been nominated for several things. You have been listed in SuperLawyer magazine as one of the rising stars there, and you've also have your degree from Columbia Law School and Master of Law from the let me see if I can get this right. You might have to help me out here. The University of Sorbonne, right?
Yes, perfect. Yes.
Okay. All right. And several other things that I'm probably missing out. So I want you to kind of introduce yourself to the audience, and then I would love for you to tell us, even just to get started, because I know you well working with you, but tell us like your story. Why are you even in this? Contracts law, for most people, it's like, oh, it's boring. But you don't make it boring at all, and you make it fascinating. So tell us a little bit about what you do, how you do it, and how you got started here.
Great. Well, thank you so much for the opportunity to be here. Thank you, Connie. So why? That's because I've always been very interested in entrepreneurship and community development. And that's probably tied to my family history. So my dad grew up in Benin, West Africa, in a very small village in the north with no electricity, no roads. And he was the only boy out of a family of 5 daughters with a single mom. So he had to walk to school for 2 hours in the morning, walk back for 2 hours. And he studied with a candle. He wanted to help people in his community deal with pain. So he wanted to become a doctor. He studied in harsh conditions, got a scholarship every year, and then made it all the way to the capital of Benin and then to France, because Benin was a French colony at the time. And he became one of the first robotic surgeons in France, leading the industry in robotic surgery. So I've always been very interested in helping entrepreneurs or people or goal setters achieve their goals. And the way I was doing it was through words. I have a passion for words, for literature. I grew up in libraries, reading a lot of books, and I created a company first that was a public writing company. And then I wanted to have more of an impact at the community, at the largest community level. So that's when I studied law. And that's why I love contracts, because they are those documents that foster relationships. And in the business world, the contracts can really help your business build solid ecosystems to thrive, and then enable your business to make an impact in the community where it acts.
Amazing story about your roots and your father and his brilliance. I mean, robotics way back when, today it's like still cool, but he was probably like, an Elon Musk back in his day. So great roots to come from. No wonder you're such a genius and such a kind-hearted person. And that's why I want everyone here to listen, is because you're going to get something amazing out of this. And you're definitely going to want to reach out to Contractologie. And it is an amazing company. But let's talk a little bit about what you want to present, because you have an interesting way of looking at contracts, helping people understand it, making it digestible for any person and any kind of business. So let's dive into what you're bringing here and what you're going to share with the audience.
Great. So we want to do this contract training for companies that want to scale their operations. The purpose here is really to streamline operations, streamline your negotiations, and make sure you can reach the next level in terms of your business development.
If anyone has to go early, just go ahead and check out contractologie.com. That's Contractologie with an IE at the end if you're just listening to the podcast. And whenever you're ready, feel free to go ahead and dive into the topics.
Perfect. Thank you. So our goal is to make you skip law school in less than an hour. So let's go. But first, I'd like to tell a story from my husband. So if you ask a mathematician what is 1 + 1, they will tell you that equals 2. If you ask an engineer, they'll tell you that equals 2. But if you ask a lawyer, they will tell you, what do you want it to be? What do you want it to be? And that's really what we do as lawyers. We try to capture the goals and aspirations of the clients we represent, so it can be fixed in a contract, in a written document. So we'll see why we have to do this as opposed to simply a handshake. And we'll see some elements of legal operations, legal apps that we can use to streamline businesses. And then we'll dive into the contract itself to see what is really important. Yes, so first of all, why do contracts matter as opposed to simply a handshake? And that's because under the statute of frauds in most jurisdictions, you need a written document to enforce the promises of that written document. The threshold is typically $500. So if you don't have a written document, it's going to be really hard for you to prove in court that you have a contract. And if you don't have a written document, it won't be a verbal promise won't be enforceable. There are some exceptions, like yeah.
Can I ask you a question here? I'm going to ask in because I'm not, well versed on all these legal terminologies, but I hear a lot of times people say, well, we shook on it, or it was a verbal agreement and it should stand. But that's really not the case. If it's more than $500, then you need that in writing. Is that correct?
Absolutely, yes. You need that in writing. If it takes more than a year to complete a service, for example, that is a subscription base and it's for 2 years, let's say, you also need a written document. So in those two circumstances, you actually need the written document to prove your case before a court of law. Yeah, so there
People
are
that are
some
probably shaking in their boots right now.
yeah. So there are some exceptions, like in the McDonald's world. There are some corporate cultures of handshakes, but in this specific instance of McDonald's, they have a strong ecosystem with stable relationships with their suppliers for over 30 years. So there is less of a risk of a conflict in this instance. But they would still need a written document to enforce a promise if they have to. The way we do our legal ops basically is that we, of course, don't want a written document for every single transaction, a negotiated contract for every single transaction, because we want to minimize legal fees and energy related to the contracts that matters the most. But for the smaller contracts, you can just have the fine print, for example, at the back of your purchase order or your invoice, and that will serve as the written document that you need. So what we do with our clients is we discuss the typical threshold where they actually need a negotiated contract as opposed to simply the fine print at the back of their invoices. And we typically give them table to streamline approvals and signatures based on the contract value of the different contracts they handle. The elephant in the room now.
Can I go back?
Oh, sure.
I want to hear about the elephant. Let me go back to a couple of things you mentioned, like on this chart. So this way you can customize it based on the size of the company, who they are, who handles what. So it's not just cookie cutter templates or something like that. It's really customized to the business and the contract and what they're trying to accomplish. Is that how you look at it?
Absolutely, yes. Every company will have their own contract thresholds, risk tolerance. So we really customize our approach to make sure these ways of functioning and these risk tolerances are addressed.
You mentioned something on the previous slide about, putting things in the fine print and, how that can work. Because if it's not, then are they subject to what the vendor or whoever they're working with, or do they get it by
Yes.
their rules versus their own?
Yes, exactly. If you don't have, for example, fine print at the back of your invoice with the language that supersedes the language of the other party, then you would be subject to the terms and conditions of that other party, which you haven't negotiated. Or if you try to negotiate the terms and conditions of the other party, then you basically have to reinvent the wheel each time and spend a lot of time and energy and money negotiating this fine print that's not yours and that's unfavorable to you, as opposed to having your own fine print. And then there is a battle of the forms, which is called a battle of the forms, meaning do your terms supersede the other party's terms or vice versa. So this is why it's important to have this fine print review to make sure you can prevail in this battle of the forms.
We're only like 3 or 4 slides in, and I've learned so much. This is not only good for me and our business, but all the companies we work with. And I think there's so many little things that people just don't even know, and it can really hurt them from just not having that awareness.
Yeah. A lot of people here will be probably asking why not use ChatGPT. It's become such a go-to legal advisor in a sense. But this is, in my experience, I've noticed that it's about 80 to 90% accurate in terms of contract redlining, but it is missing sometimes very important issues. And I'll just give one example here. I've had this case come up to me quite a few times now. A company wants to raise money, let's say $10 million. They hire a consultant to help them with the fundraising, and they want to pay them a success fee. If you feed this contract into ChatGPT, they'll give you a 90% accuracy on minor edits, payment terms, etc. But they don't notice, I mean, ChatGPT hasn't noticed when I did that, that the client could actually go to jail by entering into this agreement because the fundraiser needs to be SEC registered. So that's, the penalties are super high. If you're raising $10 million, you can lose the $10 million and then pay SEC penalties for due to that lack of compliance with SEC regulations. So yeah, let's be careful. And the second problem by using ChatGPT is, of course, confidentiality, because any information that you feed ChatGPT can be served as output to other users, and it's also your information can become public information. So yeah, let's be careful. I've had several clients come to me with either ChatGPT, the agreement that they wanted me to review, or ChatGPT red lines that they asked me to review. So that's definitely something I can do. And I definitely recommend that you get legal eyes on any ChatGPT document that you generate.
I think this is a huge thing. Right now, everybody sort of feels empowered with AI, like, I can do this. I don't need this person or this person. But it's the little things, again, that can trip people up. And also, what about when it says, like, at the bottom, do you want to share the information? Does that protect anyone from, from patent aspects? If there's a lot of new startups and things going out there that might not have spent the money to do those little steps. But if they put it out there, AI currently doesn't really have any ruling on patent protection and using other people's, trademarked content. So is that a big area that people should be looking at or thinking about?
Yes, absolutely. Especially in the context of patents, as soon as you publish something, it's no longer patentable. So this is a major red flag that people should be aware of.
I know you are awesome company at doing trademarks and things like that, getting those in really quickly. We're just talking about that. Again, this is something that Contractologie can do for your business. So a lot of people say, well, I'm just going to go see how it goes. And then if it's going well, then I'll trademark it or something like that. How do you feel about that? Is that something that people should do early or wait until they actually have a viable product or business idea?
So I think it's extremely helpful to have a strategy that's been reviewed legally speaking. And that can be for IP optimization, for patents. Absolutely, people shouldn't start talking about their ideas before they have at least filed an application, even a provisional, like a temporary application. And then it's good to have also your templates in place, so you don't have to rely on other parties' paper or on ChatGPT or the AI tools heavily.
And if anybody out there has questions, put it down in the comments wherever you're watching. And we will, if we can answer it here while we are live, because we are live, we will. But if you put it in the comments, Senami will go through the comments and reach out to you as well and connect with you. And of course, you can reach her. If you look down there on the scroll, you can see her contact information and get in touch with her and have a quick conversation to see what do you need to do to protect yourself.
Absolutely great. And we do use AI ourselves, so I highly recommend that using AI tools, you make sure that in the terms and conditions or terms of service of that tool, that your data will not be shared and that your data will not be used to train the LLM of that AI. So yeah, that's a major thing that you can make sure that you can enforce to make sure your data is protected. Yeah, so our focus is really to streamline operations. We don't only do contracts transaction by transaction, which is likely, in my experience, to fail if you look at one contract in an isolated fashion. But if you look at one contract in a system, then that's really what can take your business to the next level. So having your templates, document naming policies, as well as document management practices through a contract management system, software that will really help streamlining operations, going faster, better, more secure. And yeah, that's what we specialize in partnerships with contract management software. So through the contract management software, you can do everything from drafting through the template or through the AI, the CMS AI, if they have one. You can review without exchanging a lot of emails or losing your negotiations in a variety of emails, and then you can sign the contract and have everything in one single repository. So that's also easier to find documents later on when a new team member joins in or when some other team members need to access these crucial commercial documents. So that's an example of how the contract management software works. You will issue an intake request to have the contract initiated through the system, and then it takes you all the way to execution. And this is our team. So we basically act as the outsourced legal department for companies that don't have a legal team, or if they have a legal team, then we'll work in a collaboration with the legal team. So we have attorneys, junior, senior, of various specialties. We have legal ops professionals, compliance professionals, as well as contract management professionals to help with all the legal operations as well as legal counseling for that company.
Now, this is a lot of your sort of internal team, but you have an amazing structure that's unique in law, and that is how you've structured your whole team and all of the other attorneys that you can bring on to your team. And so, hey, if you're looking for a much better environment for your own law business, contact Senami. But tell us about the structure and how you have built that.
Yes, absolutely. So our structure is different from the traditional law firm in the sense that we are built as a mastermind of attorneys. Each attorney is encouraged to be entrepreneurial. We have a very entrepreneurial structure. We really incentivize attorneys that go out and do business development so they can really build the career and niche specialty of their dreams. And within the career of their dreams, we don't only have the content itself, the industry that they want to specialize in, but also the personal life that they wanna live can be more easily accommodated through our system because we have full flexibility, and we also have values focused on family, friendships, and financials. So we really want to help people build the career of their dreams, and we have the infrastructure basically to help them achieve that.
It's amazing how you've done that, and it also makes it so if somebody comes to you and like they could have different specialties that people are in. Like, do you have specialty that you work on and other people, or how's that work?
Yes, so for example, I'm focused on IT infrastructure, including data centers and rural broadband development companies. And we have other attorneys and experts that do other industries, such as federal contracts, such as art law, such as a tax. So yeah, basically all the different industries ultimately will be covered. That's our goal.
Kind of a one-stop shop if you want it to be that way.
Exactly, and I've often found that as an attorney, we often are a little isolated, but when we are a mastermind of attorneys, the way we're structured, we can really bounce off ideas of each other. We cannot be an expert at everything, but we can run our ideas through other experts so we can deliver more quality work product. Well, thank you.
Right.
So I'll move on to anatomy of a contract. So the core of this presentation is to let people know about the important key terms of a contract, and we'll focus on independent contractor agreements, especially because for scaling companies, this is a crucial document to hire with flexibility without having the overhead of employees. It's also crucial because the risks are high if they label an individual as a contractor as opposed to an individual. There are high requalification risks and damages that would be owed in this case. So it's important to do a good due diligence when making that decision up front, so companies can avoid the penalties.
So you're going to break it down, what needs to be in that contract, what it looks like, using that contract worker as an example to give people an idea, because I think that's huge. So many people are going into that space and they're not doing the traditional job thing and like, oh, I'll just come on as a contract worker or hire a whole bunch of contract workers, people always say. But you have to really pay attention here. This is interesting to me because we do this a lot. So thank you.
You're welcome. My pleasure. So first of all, we have the three main elements of the contract, and that's more or less across the board for every contract. We first of all need to make sure that we know what the contract is for. What are we buying? What are we selling? We need to be extremely clear on the scope of work to avoid scope creep or avoid differences in interpretation here. Second thing is the price and the payment. We have to make sure there's a very specific price and that the payment terms align with your practices. For example, net 30 if you're a buyer, net 15 if you are a seller, and you want to be systematic with this across the board. The last element here that is very important is the term. And ideally, you want to avoid auto renewals so you can have this ability to control the costs and then have a set end date when you can renegotiate the contract if needed. But if you're a seller, you will want auto renewals, of course. So these are the three main elements of the contract. And then now we'll discuss protection mechanisms. So first of all, there's insurance. First protection mechanism, you would want to make sure that the contractor you hire will have insurance. If it's an individual, they will unlikely have commercial insurance, but we'll discuss that if you hire a contractor, you should actually make sure that they are organized as an LLC or as incorporated as a company to avoid the risk of requalification, depending on whether or not they are a profession that's within the line of your business, or if it's just a photographer that comes in for 2 days or one day, one afternoon to your office, then you wouldn't need to require this. The risk would be lower, that there would be a requalification. But for those professions that are in line with your business, like if you hire a secretary, let's say, or if you're a business consultant and you hire a contractor as a business consultant, it's ideal to require that they are a company as opposed to an individual. And then in this case, they would have insurance, basically. The second element is indemnification. So it's actually one of the most highly negotiated legal terms. Indemnification means that if you have any damages incurred as a result of the relationship with that contractor, they would indemnify you, they would compensate you for the damages that you have incurred. So it could be indemnification for damage caused to your office, or injury caused at your office, for example. It could be also if you hire, for example, a designer to work on your logo, you would want them to indemnify you in case of infringement. If they copied the logo from another company and this other company sues you, you want to be holding this contractor accountable and make them pay for the damages you owe to that other company. And then
Senami, can you also, I'm sorry, can you also do this indemnification with something more intangible, like reputation, if they damage your reputation? Is that something that you can pursue?
Absolutely, yes. Yes.
I'm
So
thinking
typically,
with even influencers or other things like that, that people might do something and harm. Okay.
absolutely, yeah. So typically an indemnification will be for breach of contract. So if you haven't specifically included a non-disparagement clause in your contract, then you would want to you would only be indemnified for damages to your reputation if you have included the specific terms in your indemnification clause. And then the last item here for protection mechanisms is limitation of liability. You would want typically to cap your liability at a certain amount, which can be, for example, the amount payable under this contract or paid under this contract, and that helps you limit your exposure. That's especially the case for tech companies that use data, because data breaches are very costly typically if there's a data breach that is typically at least, it could be a lawsuit in millions. So we really want to cap a liability in these cases in case of to avoid data breaches. So insurance, these are some elements that can help negotiate the insurance section, basically. So you would want a few certain policies to be had, depending on who you work with or depending on the nature of the work. If they use a car, for example, you will want them to have car insurance. If they have employees, you will want them to have a workers' comp insurance. You will want them to have CGL, commercial general liability, depending on the nature of the work. And you also want them to have insurance policies that are primary and non-contributory, meaning that if there's a damage, their insurance company will pay for this damage and yours won't, basically. You also want to make sure that that they show this certificate of insurance to you before starting with the work or as soon as you request it. And you also want the insurance to survive the term of the agreement, to make sure that if a damage is discovered months later after the termination of the contract, that you can still be reimbursed by the insurance company, basically. Other protection mechanisms, so indemnification we discussed, those are some examples of items that you would want indemnified. So death or injury to a person, damage to property, breach of contract, negligence or misconduct, data breach, infringement of copyright. Compliance, you also want the contractor to comply with all laws, but not only this, also with your policies. And in terms of liability, you want to make sure that the contractor is responsible for their own methods of work, which is one of the criteria to indicate that they are indeed a contractor versus an employee. And you also want to make sure that they are responsible for any subcontractor or agent that they would want to hire with your permission. You wouldn't want them to hire subcontractors without your permission, since you want to know who you do business with down the line. Oops, apologies here. So the warranty is also an important element. It has to be in line with what you can offer. If you resell a product, for example, you only want to pass through manufacturer's warranties, but you don't want to commit beyond this. And yeah, if you have a contractor, you also want to make sure that they commit to the highest industry standards, use their best efforts to do the work, and you need the independent contractor section to make sure that they understand they are not an employee or in a partnership with you, but they are only a contractor. Termination is another important element. You need to make sure that you can get out of a contract when you want to. Ideally, typically upon 30-day notice to the other party. And if you sell a product, you will want to try and make sure the other party commits to a certain amount of time, so you can get paid for a certain amount of time, basically. But another important element is to make sure that the parties know what to do in case of termination. For example, if you hire a contractor, you will want that contractor to delete all your confidential information when they are done working with you. You will want to make sure that you will only have to pay them for services prior to the termination date, and not for anything that they might do after you tell them that you wanted to terminate the contract, for example, so you don't have a surprise in terms of invoices, basically, that they would send you. Subcontractors, yeah, we briefly discussed them before. We want to make sure we have visibility over them, and confidentiality, depending on the deal. We typically want the information that we provide to any contractor to be kept confidential. And we want this section to survive also if they terminate the agreement with you. You still want them to keep your information confidential after the end of the services. IP now. That's a very important issue for certain companies that for the companies that create materials. So in this case, we want strong IP language that makes sure all the IP is protected in the contract, including for derivative works. So for example, if you hire a contractor to design your logo, for example, you will want to own these deliverables, as well as any derivative works that you might do with this logo. If you slightly change a comma in the logo, you still want this logo to be owned by you. Fallback is getting a license as opposed to a full ownership over the deliverables, but this is not ideal because it's because that means the contractor will remain the owner of that particular material and then can resell it to other clients, or doesn't basically can do what they want with that particular piece of material. So you really want full ownership as opposed to a license. And you also want, on the data protection side, to make sure that your data is confidential and that the contractor will notify you in case your data becomes public, or if there's a threat to this data.
It's a big area. I see this a lot with our clients as well, is that, you know, we always talk to business owners about what is your IP, right? So that you do stand out and you're not just like everybody else. And I think a lot of times people aren't paying this enough attention and they're not protecting themselves. And I've seen where different designers actually created duplicates of brands for two different people. I mean, what's the coincidence of me having both, right, as a client and the same brand from the same designer? But, you know, that can be a big factor and a very expensive mistake if you're not paying attention to this. And I think on something like this, the earlier you take care of it, the better, because in this day and age, your brand is everything. And if you're not protecting that IP, you could easily, just like that, lose your whole business.
I agree. Yes. And then there are other things that are more minor from a business standpoint, but important legally speaking. The first one is the publicity clause, which is also known as a use of name clause. So basically, if you hire, same example, a contractor to do the design for your logo, you wouldn't want them to use your name on their website saying that they helped you with this logo design, unless they give you a discount on the services. So that's you want to control your brand name, make sure you know where it goes, and that you can revoke any consent that you gave to an entity to use your name for marketing purposes. The second important boilerplate clause is the choice of law. You want to make sure that you place yourself in a jurisdiction that ideally you reside in, or that you are familiar with or have contacts in, to make sure you don't have to litigate in Kazakhstan or wherever else the contract may be located. And you also want to make sure you understand the law of that jurisdiction. So it's important that typically you would want to stay home. And then the entire agreement clause is basically saying that this agreement is the entire agreement between the parties, that there's no other verbal agreement. And that's also important in case of a dispute, because you don't want people to bring an email or any other written document or even verbal statements that you may have made to alter the written document contract that you have. You want to make sure that this is the entire depiction of the entire understanding between the parties. So with all of this, you will be strong, and there are other general provisions such as the fact that there shouldn't be an amendment without it being signed by both parties. Make sure you have no assignment unless you consent. No assignment meaning no transfer of the contract to another entity without your consent. You may, if you think that you will be potentially acquired, you may want to preserve this right to assign the contract to someone, another entity that acquires your business. You want to make sure that this contract will be recognized as a properly signed if you simply exchange PDF signatures, and you also may want to add language saying time is of the essence is if you really want the contractor to commit to very specific deadlines for the delivery of your materials. If you don't have this sentence and they are 2 days late, you had to publish, let's say, a magazine, they are 2 days late and produce the work after the publication of the magazine, then you still have to pay them. They're not in breach of the contract. But if you have the time is of the essence clause, then you can hold them liable and argue breach of contract if they are 2 days late and you missed your publication deadline. So this is anatomy of a contract in a nutshell. And that was for commercial contracts. Now for federal contracts, they are slightly different. But if your company handles federal contracts, there are still a few items that can be negotiated, although in a minor fashion, and sometimes it cannot be negotiated at all. So it really depends on the procurement method. But in this case, there are heavy compliance requirements. So in this case, it's really important to focus on contract compliance, and also for contract management purposes, it's important to make sure that you have the federal requirements that have been updated last November 2025 to make sure that you can store your documents in a federally compliant way.
New, this law?
Yes.
Or
So yes, absolutely. Since last November 2025, document management has to be CMMC levels 1 and 2 compliant, and that's required to be able to do business with federal entities. So yeah, depending on the nature of the business, that's definitely something that needs to be updated if companies are not CMMC compliant. And that's it.
awesome. So this was really, really interesting. I want you guys to think about all these little areas that you might be missing something. You might know somebody. I could think of about 6 or 7 things that people are doing wrong right now that I want to go to. And, sometimes it's just good to have another eye, right? As we say, AI is a big thing, but it is not everything. And you still need human oversight when you are looking at some of these things. And this is one of the best places to go. And as you can see, Senami has a wealth of knowledge in all different areas, and not one of these experiences that you're like, ugh, it was like going to the dentist or going to the attorney was like, you didn't know which was more painful, and now she's changed that whole thing. So she's an amazing person to work with. If you have any questions, reach out to her. Put some questions down in the comments whenever you're reading this so we can reach out. And where else can people find you? What's the easiest way, Senami, for people to find you and do business with you?
Thank you. The easiest is through LinkedIn. You can easily find me. You can also email or call through the emails that are shown at the bottom.
Okay, awesome. So wherever you are, if you are on the side of being an attorney and you want to have a much better experience in your career and work with this mastermind of attorneys, it's a completely new concept that will get you out of the grind and the competitive dog-eat-dog world of trying to get to partnership. And if you have a business, you have to protect it. This is your baby and you don't want a little mistake to completely wipe you out of the game, then you definitely want to reach out to Senami. And thank you, Senami, for coming on, enlightening us. And I hope as time goes on, we'll do some more. If you guys have areas in law that you really want to know about, we'll be happy to bring Senami back and talk about different things. And again, protect yourself. And she will simplify everything. And you will, like she said at the beginning, you'll feel like you just got a law degree in less than an hour after working with her and watching this. So thank you again, Senami, for being here.
Thank you so much for the opportunity to be here, and thank you. Yeah, let's have a good day.
My pleasure. And if you have a business that you would like spotlighted on Spotlight on Success, and you feel like you have an iconic business, you're an iconic leader, we would love to highlight you, share your information with the world. And we are always supportive of entrepreneurs and business owners who are making a difference. And we look forward to seeing you on the next show. Have a great day, everybody.